May, may,
May I please, Your Lordship? The concern other side, I beg to mention item number 3, my lord. In this case, I have to file a reply, my lord. I prefer tweaks time, my lord.
Item number 3.
3, my lord.
What type of application is from respondent number 5?
Pardon, my lord.
Respondent number 5 is moved some application.
My lord, we will not be.
I first will not file. We have filed an application.
What application you have filed?
Yes, we have been newly implemented as Election Commission of India in this matter, Your Lordship. So we beg to file an affidavit. They have filed, sir. We have filed an affidavit. They want to file a reply against our affidavit in opposition.
Affidavit has been filed by the ACI.
On file a reply, my lord, to the affidavit.
You are for the respondent number?
I am for the petitioner, my lord.
You are for the petition.
Petition.
Okay, at the request of the council for the petitioner, this matter after 3 weeks.
My lord. Deeply applied.
May,
Yes,
may please, item numbers 5, 6, 7, and 9, madam.
5, 6, 7. and
I
9.
pray for a short accommodation, madam. I'm led by learned senior counsel, Mr. K. N. Chaudhary, madam. He's on legs in a different court in the part-heard matter, madam.
Then these are the 5, 6, 7, and 8
8
9.
and 9.
9.
Same. 5 to 9.
Please note that respondent number 9 have not taken steps. Respondent number 9. 29/11/2023.
So you are for the,
We appear for petitioners in item number 5, 6, 7, and 9. Whereas 8 is a similar matter.
in fact, you are required to take some steps in respect of respondent number 9.
Mr. Mohanty, you are the counsel in item number 5.
5, madam.
There's an office note of 29/11/2023. That steps on the respondent number 9 is yet to be received. We have not taken steps.
The respondent number 9, madam, in fact,
Check the court records.
my lord, respondent number 9 is, my lord,
I am the appellant, respondent there, and I am the appellant in 8, item number 8.
Number 8. You are for the respondent number 9 and item number 5?
In 9, in his petition, my lord, I am the respondent. However, I am also the appellant in item number 8.
we are not
Okay.
seeking any relief against my learned friend's client, my lord. We're similarly situated, in fact. It arises out of a same judgment and order. my lord.
This is the learned counsel, Mr. So and so for Mr. K. N. Chaudhary, senior counsel. Please, this matter. When?
The first week of April, my lord, if it's continued.
2nd of April,
3
my lord.
weeks. After 3 weeks, get the date from.
Diploma.
Date may kindly be, my lord, with some urgency. A date may kindly be.
Ask the court master.
I'm
Yeah, after
very
3 weeks,
grateful.
he'll give the date.
I'm very grateful. Court will-
Any other question? Mention, no? May I please, Your Lordship? First, I can mention one item for listing. My lords, it was fixed today, my lords.
Item for listing the matter.
Yes, my lords. It was fixed today, my lords. It was last listed on 12. It was fixed today, my lords. Somehow I couldn't make it, made it to the cause list today.
Next week, now, whatever day.
My lord, can it be on Thursday, my lords? It's a highway matter, my lord, was
Not be here.
construction of highway, my lords, was supervising the matter, my lords.
Okay, Thursday.
Thursday, my lords.
I beg to mention for listing, my lord. New case, my lord.
Item number?
My lord, paying for listing, my lord.
Yeah. What's the
Day
matter?
after tomorrow, my lord.
What's the matter?
My lord, read appeal, my lord.
Right away, what's the urgency?
Yes. My lord, just file on the 15th of
Next week, now, whatever the date.
Lords, I beg to mention an urgent writ appeal for listing on Wednesday, my lords. The writ
Why,
appeal-
what's the urgency?
My lords, it arises from a judgment which has allowed more juge, my lords, the buffalo fights during the duration of Bihu. Therefore, my lords, on day after, I seek an urgent listing. There's counsel who's engaged from outstation also, my lords. Therefore, I beg, my lords, your
So the
lords.
learned single judge allowed that.
Yes, my lord. The learned single judge has allowed it, and then there is a cabinet decision which has been filed, my lords. So those are impugned in this writ appeal. There's an SOP also which has been passed by the government of Assam, my lords.
When this, whatever the event is scheduled to be held.
My lords, in the month of April, my lords, the Bihu is upcoming.
April.
Therefore, my lords, there's a slight urgency, my lords. I humbly request. My lords, if Wednesday is
Friday,
possible,
Friday.
very well, my lords.
May I plead your lordship? Lordship, I beg to mention for listing lordship, writ appeal lordship.
What's the urgency?
Urgency lordship, last occasion matter, last posting date 19/2 lordship, respondent take time lordship.
April, May date.
Obliged.
Lordship, I beg to mention item number 16, Lordship, for adjournment.
1-6.
1-6, Lordship.
You are for the appellant.
Yes, Lordship. This matter will argue Senior Advocate R.P. Kakuti, Lordship, due
The
to some
request of so and so urgent.
next week, Lordship. And
Next week, it's very difficult. Next week, how many days, working days are there?
next week, 27, 28, Lordship.
The 7-20 April, May, whatever date, April.
I'm obliged, Lordship.
Yes,
Daily list for orders item 1.
Reply to file to purpose.
yes.
My lord, in this case, today in the morning, we have filed an affidavit in opposition.
On behalf of whom?
On behalf of the private respondent number.
Three. Respondent number 3. And what about, you have not taken any steps for respondent number 2 and 4?
We have taken steps, Lordship,
Yes,
and even we had
this is office note.
first steps, once already we have taken steps. And additional affidavit also we had filed, Lordship.
But the office report is otherwise.
We will take fresh steps, Lordship. We will take fresh steps.
This is the old pending matter. You should take steps at the earliest. 18 matter, 4 steps, it's lying.
Within 2 days.
Within 2 days, we'll take again fresh steps, Lordship.
Okay, as per the office report, no steps for issuing fresh notice upon the respondent number 2 and 4 has been taken. Learned counsel for the petitioner prays for and granted 2 days time to take steps. Full stop. On doing the same, let notice be issued to the respondent number 2 and 4, returnable through registered AD on the date April ki second week ki whatever the date. And the counter affidavit filed on behalf of the respondent number 3 also placed on record.
May I submit one thing, Lordship. And respondent number 2, Lordship, they have a standing council.
Shillong.
Shillong. Deeply obliged, sorry. I'll take steps, Lordship.
Yes.
Item 2. Lordship, I filed an application for amendment of the cost title.
When you have filed?
Lordship, yesterday, Lordship.
Okay. Quickly, and counsel for the appellant has submitted that IA with a prayer for placing the amended cost title on record has already been filed. Office to check, and if the same is filed, let the same be placed before this court
Much
after a week.
Item 4.
But the appellant has filed an IE, my lord, for placing 2 documents on record which were not before the learned single judge. My lord, because the learned single judge disposed of the writ petition on the basis of the selection records, the original selection records. So these 2 documents, my lord, were not part as such of the WPC.
Fine.
I only pray that these 2 documents were not subject to any.
My lord, in this case, though they were represented by, he represented the department, but no affidavit was filed. After the notice of issued, they were represented and appeared on every date, but there was no prayer for filing any affidavit. So accordingly, the writ petition was decided on the basis of the materials that were on the record. So here they have filed an application, but they have not given the reason why the affidavit could not be filed. And my lord,
That we'll consider, but if the learned single judge has taken into consideration some documents which are not already on record, what's wrong in that? If
no,
he
my
is
lord,
asking for,
it is not that the learned single judge decided the case on the basis of this document. These were not there in the record. So they are trying to introduce this for the first time in the appeal. No,
yes,
if it-
Mr. Where the learned single judge referred to those documents?
No, my lord, the learned single judge, my lord, if your lordship comes to the impugned order, my lord.
Yes.
The relevant part at page 43, my lord.
Internal page of the judgment,
Yes. No,
internal page
internal page of the judgment is page 4, my lord.
4, yeah, read.
Yes. Now, this part, my lord, record produced by Mr. Ganguly reveals that there was no cutoff mark fixed for consideration of the candidature of the officers who had appeared before the selection board. As a matter of fact, rules of 2017 also do not permit fixation of any such cutoff mark for promotion from MMG scale 3 to MMG scale 4. A careful examination of the departmental records also goes to show that the selection board had not fixed any criteria based on which candidates scoring marks below a particular level could be denied promotion. Now, my lord, in this part, my lord, the selection records
fact,
was placed before the before the learned single judge.
But the learned single judge perused the same and simply made a factual remark and nothing else.
Yes, my lord, but
It is
my
not
lord,
taken- So is your case is this that you have fixed the cutoff mark?
no, my lord,
No.
our case was that there could not be any cutoff mark fixed because the rules do not provide as such for any cutoff marks.
So the learned single judge has plainly recorded, there was no cutoff mark fixed for the consideration of the.
Yes, my lord,
That's all.
yes, my lord, but
We'll
the,
take it as it is.
no, my lord, the selection record was seen in its entirety, my lord. The entire selection record was before the learned single judge. These two documents are part of the selection. So how he is prejudiced? I can place the original also for perusal of your lordships. Lordships may examine that. But let this be on
Well,
record. He is
requirement
not
of that
prejudiced.
will certainly ask for you
Lordship,
at the time of hearing,
lordship, we'll place
the
this.
IA number so and so. Whenever if the court is in requirement, court will ask for
Lordship.
the IA number so and so. Will be considered at the time of hearing of the appeal number 269/2023.
Lordship,
Office will proceed.
I will.
Item 10.
My pleasure, Lordship.
Yes.
Lordship, the office note indicates that although notice upon the respondent number 1 was issued on 27 to.
Service not complete. or
Not
the-
complete.
You are appealing for the.
Correspondent 2,
1 and 2,
only 2,
only 2.
only 2.
It was dispatched on 27 June, sir. Maybe after the complete 1 minute, or maybe the first people.
Await return of notice of respondent number for 2 more weeks. Will await notice for 2 more weeks.
Obliged.
Item 11. Actually, in this case, the Lordship Court order dated 1/3/2024 indicates that although the respondent received, the document has been delivered to him, but neither ID card nor unserved notice has been received back. Earlier, we took steps that was returned unserved. Then we
Appeal was dismissed for default. They filed for restoration. That is barred by 290.
Okay.
And they have said that because of expiry of the panel. This case was only for restoration of the appeal, MC, and the file is for release confirmation. Is this?
As per the office report. Notice, service of notice upon the full respondent is complete. Stop. However, none has put in appearance on behalf of the respondent number 1. The matter comes upon for consideration of the IA number 1393 with IA number 5/21 for condoning the delay of 291 days.
Lordship.
291 days in filing the restoration application. Full stop. The IA number 5/21,
So that is ITA.
ITA,
So
sorry.
ITA.
Acha, ITA now.
ITA is the appeal, and which
ITA.
case is 34 is the restoration. 34 is miscase. I think the restoration application. Let's go.
Okay. This IA is for.
Is the combination
what
of
is
the
it? None present on the above, so IA number 1393/2023 is preferred on behalf of the appellants with a prayer for condoning the delay of 291 days in filing the rest MC number 34/2023. Full stop. Having gone through the contents of the application, we deem it appropriate to allow the IA number 1393/2023 and condone the delay of 291 days in filing the MC number 34/2023. Hence, the IA number so and so is allowed. Full stop. Having heard the learned counsel for the petition and after going through the contents of MC number 34/2023, we deem it appropriate to allow the same and allow the same. Hence, the application number MC number 34/2023 is allowed. The ITA number 5/2021 is restored to its original number. Office to proceed.
Much of.
Item number 12.
Thank you, Lordships. Lordships, in this, I am praying for condonation of a delay of 62 days in preferring a writ appeal, your Lordships.
Right.
Lordships, the appellant here, he is a unemployed person and he had some financial problems due to which there was some delay on his part.
Do you have any objection?
My lord, I have one issue, my lord. My lord, in this case, the appellant is challenging a selection list from the year 1995. So, my lord, this advertisement was issued by the Directorate of Industries and Commerce. And subsequently, the selection list was issued in the year 95, where his name was in serial number 80. And the respondents whom he has impeded were at serial number 99, 104, and 109, down below him. So, my lord, the main answering party here would be the Standing Council Industries and Commerce, whose name is not reflected in this cause list, my lord, today.
Whatever it may be, we are simply
Yes.
condoning the delay and
Well,
nothing else.
as far as the TNRD, I'm representing the Panchayat department, my lord. I do not have any objection as such. As far as the industries department is concerned, my lord, that would be
The
their.
notices of this
Not been issued.
notices have not been issued till date.
No, your Lordship.
No.
Issue notice of the IA number so and so. Mr. So and so put an appearance on behalf of the respondent,
My lord, I'm for the PNRD department, Panchayat department.
Panchayat department, which respondent?
Three, my lord, three,
Respondent
lord.
number three.
three.
Mr. So and so is appearing on behalf of the
Oh,
respondent.
the main party
Let
is the
notice
industry.
be issued to the respondent number 1, 2, 4 and 1, 2, 4, 5, 6. 1, 2, 1, 2 and 4, 2. 17. Returnable. 6 weeks. Requisites be filed within a period of 4 weeks, within a period of 1 week. Yes.
Thank you. Oblige the Lordship.
Item 13.
Item number 13.
Issue notice to the I number so and so. Returnable on, we are appearing. What two? Mr. So and so put in appearance on behalf of the respondent number 2, lest a notice be issued to the rest of the respondents. Returnable, you are. Respond, Mr. So and so is appearing on behalf of the respondent number 2, and Mr. So and so is appearing on behalf of the respondent number 4. Let notice be issued to the rest of the respondents. Returnable on so and so.
Item 14.
That was not complete on respondent number 1. Who
It's
is
not complete,
respondent
your lordship,
number-
as per office note dated 14 March 24, neither AD card has been received nor the notice has been received till now by the section.
On?
As per office note dated 14 March 24, your lordship.
14th March 23.
24.
24.
AD card hasn't been received, neither the unserved notice has been received, your lordship.
It was issued on 17/2/2024. Notice of postponement has been received. Consent change. 17/2/2024. That's were taken on 29th, so I think we'll get released. Here.
What is this?
Within date of the order.
Date of
Of course, order.
report order. Await return of notice of respondent number 1 for 2 more weeks.
For admission, item 15.
Lordship, the similar appeal has already been admitted, Lord.
Compassionate appointment.
Yes, Lord.
Compassionate appointment.
Yes. Lord. The order copy I have, Lord.
It's clear. That is clear. But have you challenged the original order of Bhaskar Kumar?
Yes, Lord.
That is also under.
Yes, yes. It is a separate appeal we have filed.
Separate appeal.
Yes. In fact, in respect of all the petitions, we have filed separate appeals.
This is.
Same order.
Lordship.
Item 17.
May I please, your Lordship?
Here what happened is actually the builder, they constructed 6 numbers of flats. After selling all the 6 flats in 2015, 16 and all, in 2020, with the only of the land paper, they have taken illegally a loan from the Bank of Baroda, which we don't know. We had purchased the flats. We had also taken a bank loan from other banks actually. We are going on like this way. Suddenly on 28/2, we receive a notice from them actually, not to them actually, through the builder actually, that the whole flat has to be vacated. The thing is that why we have came here actually, the fraud has been committed to us, and actually
Where is the position notice?
vacated notice is that your lordship page number 23.
Page number 23.
I'm so sorry, my lordship. The vacation notice page number 45.
45. What about 43? 44?
43 and 41, 41 and 42. Let these are the actually
Just a minute. This is that page. This is page 15. 15 is the agreement. Please come to 16, page 16. The drag at the top. First. There is the. Under the. We want to. See, yeah, we want to. And you come, you will say that we need to. There is no mistake, sir. You want to. Basically, you said it. You want to. Yeah. And here, come to the next document, at page 19. Here is the loan taken by him. See the dog number here. 2125. And his number 2125. Second page, this group for the builder, he is a personal guarantor. Here they didn't connect with page 25. 20, sir. Next page. Personal guarantor. Next line, personal guarantor.
There is something fishy in the facts itself. And it's better you approach the debt recovery tribunal and we are not going to entertain such petitions.
Lordship, the thing is that because of the South.
And if you want to argue, then we'll pass an order on merits. Observing that there is nothing but in connivance with the builder, you are under this litigation before this court.
Lordship,
We can very well observe. We have already gone through the documents.
Yes,
If
yes,
there is a
Lordship.
difference between the documents, then please try to understand.
Lordship, the similar matter of the two flats is also has been filed over here, which has been the registry had wrongly gone to the Honorable Court number 20.
Whatever
So-
it may be,
Huh.
here the matter is before us. And if you want an order on merit, certainly we'll pass an order on merit, then at your risk, or otherwise you go and approach the debt recovery tribunal under section 17, that's all.
My, your honor, if you could like to state that as per your, as per this court is, we will go. But the thing is
We
that.
will go near, it's your choice. We are not directing you.
We
You have an
shall go and at least,
efficacious remedy. You go and challenge whatever the proceedings before the debt recovery tribunal. The
Lordship,
Supreme Court has already deprecated this practice of entertaining petitions under Article 226 and loan matters. We are not going to.
Lordship, here actually the South Indian Bank case is there actually. We said, Lordship, then I could only pray for this court actually. Okay, we will go. The flat holders will go. Just give me a 7 days time.
We are not going to pass any interim order. We'll simply observe you wants to withdraw this petition and to avail alternate remedy available under section 17, that's all. Or otherwise we'll pass an order.
Lordship, as you think fit, but that's, I
As
feel
you
like,
think it is your choice, sir.
no,
We have already expressed our opinion.
yes.
Now, it's your choice.
Okay, Lordship.
Wants
I
to
will-
withdraw?
Yeah, I will do it right.
Learned counsel for after attempting to argue the matter for quite some time, learned counsel for the petitioner submitted that he wants to withdraw. He on instructions has submitted that he wants to withdraw the petition with liberty for the petitioner to avail to file appeal under section 12 to file proceedings under section 17 of the Securitization Act 2002 before the debt recovery tribunal dismissed with liberty as prayed for. Dismissed as withdrawn with liberty as prayed for.
Item 18.
Easier land. visual and visual grazing laws. And the policy has in fact not only deprecated but given directions to all states, to everyone from media and community land or ground sabha.
How you are aggrieved by the
My lord,
order of the learned single judge?
my lord, only thing is this, my lord. We are entitled to 1 bigha. But landed singles has given us half bigha. That is the main content.
Learned single judge has given you,
1 big, half bigha.
where is that?
Yes, my lord.
Where is that?
That is impugn order at page 167 onwards, my lord.
Internal page of the judgment.
My lord.
Internal page.
My lord, internal page 169.
Internal page of the judgment, sir.
My lord, 34. Internal page 34,
Yes,
35.
para number
5, my lord.
5. So where is the mention of half bigha or 1 bigha?
Yes, my lord, hand bigha. Half bigha is mentioned, my lord.
Where is that?
Accordingly, court therefore grants liberty to the petitioner file application. Para 8, my lord.
Yes,
Within 30 days from today, seeking allotment of land as per extent of land policy of 2019 Government of Assam. The respondent authority is District Commissioner Barbata. Revenue Disaster Management of the Government of Assam shall duly consider the application of the petitioners. Take into consider the instant applications are continued possession of the petitioner and title. It is further made till disposal of the policy no coercion. My lord, half bigha I am mentioning, my lord.
where is that?
Yes, that is there, my lord.
Paragraph 2. The ground under which they were not undertaking anything, but still done. Waste land area.
So they in whole judgment, there is no mention of half bigha word even.
My lord, half bigha means that 2019 policy, my lord.
Whatever it may be.
2019 policy will apply. That is half bigha.
So that's right. If the
2000
2019 policy is applied,
2019 policy is applied, my lord, that will be half bigha.
so what's
So, my
wrong
lord,
with
my humble submission before your lordship would be pleased to see. See page 102, my lord, 102. Here, my lord, second paragraph, my lord. As per local inquiry and verification done by the CO Borbata Circle, along with revenue staff so and so, 74 bighas of land, that is at the rate of 1 bigha land for each writ petitioner. So, my lord, it is a decision of 2013. Land of 1 bigha was allotted to us.
Then
Now, my lord, the learned single judge, my lord, say that 2019 policy will apply and only half bigha land will be given.
sir, the learned single judges, nothing is observed. Learned single judge has simply said, can't be regularized pursuant to, in view of the judgment of the Honorable Supreme Court.
Yes, my lord.
However, if other wasteland is available with the government of Assam, that can be taken into consideration for
That
allotment.
part
And he has
is all
simply
right,
said
my lord.
this, nothing
That
else.
part is all right. Only grievance before your lordship is this.
No, we are not.
We are entitled to 1 bigha, my lord. 1 bigha
you-
was allotted to us.
You just make your representation before the authorities concerned, they'll consider it, whether you
No,
are
no.
entitled for half bigha, 1
Representation-
bigha, 2 bigha,
My lord,
5 bigha.
representation, they will consider as per policy 2019. my lord.
So what is which policy is under vogue?
My lord, in our case, my lord, the earlier 1989 policy should apply because
That is
in
not your case, even
2013,
Mr. Singh, come to the relief you had prayed for in the writ petition.
Sure, my lord,
The prayer in the writ petition
prayer in the writ petition,
is 90.
90.
It seems you are deviating from the writ petition. It's an independent prayer. First relief is to hand over the allotment certificates. Second,
Yes, my lord, and de-reserve the order of communication dated so and so.
and third,
Reservation order
to
communication dated so and so.
remove the condition that if it's not utilized within 3 years.
My lord,
There's not even a reference to 19 policy.
my lord.
This petition you had filed, there is no further pleadings, nothing. So how do you bring in something independent? This is a continuation of the proceedings.
My lord, that is there, my lord, but our thing is this, my lord, land of 1 bigha was allotted to us. Allotted to us, my lord, that is at Annexa 3. Page number, your lordship, page number 102. Your lordship will consider, in 2013, government decided to give us 1 bigha of land.
Where is the policy of 2019?
Yes, please.
Not even a subject matter.
2019 policy, my lord. Government of land policy.
Supply us, copy.
My lord. Yes,
Supply us the copy of that.
possibly available here. Land policy.
It's to be specifically challenged by this. That will prevail, that will prevail.
And you are seeking allotment of 1 bigha of land on the basis of your earlier allotment.
Yes, my lord, that was allotted to us.
Allotted, that was a public land was allotted or what?
Sorry, my lord.
The nature of the land which was allotted earlier,
My lord, that land was reserved for
community lands,
not community land, my lord, grazing reserve.
grazing,
Grazing reserve.
and certainly that can't be allowed.
No, my lord, that was earlier there, but after Supreme Court,
Now, after the.
after Supreme Court decision, that cannot be. That is there, my lord.
Court judgment,
But
it can't be allotted.
Only thing is this, my lord, your
Yes.
lordship. Only thing is this, my lord. Learned single judge is satisfied to give us land half bigger
That's right.
and interim protection also given.
Yes.
But our contention, we are fighting the case from long time. Only possession was not given. 2013, my lord, your lordship, again, I am placing before your lordship in
Mr. Constable,
2002.
whatever the policy is in vogue,
My lord.
allotment has to be made in accordance with that policy, not in accordance with that earlier 1 big of grazing land was allotted to you, so therefore now also you are entitled for
No, my
1
lord,
big of
I'm
land. that
not on
can't be-
grazing land, my lord. I'm not on grazing land.
Yes.
But land was allotted for 1 bigger. Supposing grazing land is not, it cannot be
The
given.
policy which is.
But
in
regarding
vogue-
this, my lord, allotment of 1 bigger, my lord,
Yes.
1 bigger of 2013. Now, my lord, only thing is this, my lord. On the basis of this, grazing land may not be given to us. But
Can't be.
a river.
Can't be, may
Can
not
be,
be, can't
but-
be.
But regarding this 1 bigger of land, my lord, it is preferred that we are river eroded people, agricultural people, my lord. 1 bigger, now it has been turned to half bigger.
Fine.
That is not proper, my lord.
Anything else?
My lord, that is the main contention.
This writ petition is filed by the
And
appellants being agreed with the order dated 9/8/2023 passed by the learned single judge in WPC number (1916) 2016, whereby the learned single judge has disposed of the writ petition filed by the appellant with the direction while granting liberty to the appellants to file application within 30 days seeking allotment oblique settlement of land as per extent land policy of 2019 of the government of Assam. It is further directed that on receiving such application, the Disaster Management Department of the government of Assam shall duly consider the applications of the appellants and also take into consideration that the instant application appellants are a continuation of the also take into consideration and has further directed that till the disposal of the application of the appellants, the respondent authority shall not take any coercive action against them if the application is filed within 30 days with supporting documents. Full stop. Learned counsel for the petitioner appellant has submitted that in the year 2014, the appellants were allotted 1 biga of land each, which is a grazing, which is recorded as grazing land in the revenue record. However, in view of the decision of the Honorable Supreme Court in Jagpal Singh and another versus State of Punjab and others reported in 2011, in bracket 2011 and then 11 SCC 396, the said allotment regarding the community land cannot be approved. And therefore, the state government, the state authorities have issued eviction notices to the appellants. They submitted that against the said eviction proceedings, the appellants have approached the learned single judge. And the learned single judge has disposed of the writ petition while directing the state to consider the cases of the appellants for allotment oblique settlement of the land as per the land policy of 2019 of the government of Assam. However, in the policy of 2019, only half biga of land is but as per the policy of the 2019, only half biga of land for half biga of land can be allotted. It is submitted that when earlier the appellants were allotted 1 biga of land each by the state of Rajasthan, by the state of Assam, the learned single judge should have ordered for settling 1 biga of land in favor of the appellants. Stop. Para. Having heard the learned counsel for the appellant and taking into consideration the material available on record, we are of the view that the said contention of the counsel for the appellant is without any merit and cannot be accepted. It is settled that the allotment of land oblique settlement, allotment oblique settlement of land is to be done as per the policy in vogue. And at present, the policy regarding allotment oblique settlement of land to the landless persons is clearly provided, a policy for so and so clearly provides that only half biga of land can be allotted oblique settled in settled, then the no direction of allotment oblique settlement of more than half biga of land can be given. In view of the above, we don't find any merit in this appeal. The same is therefore dismissed.
Item 19.
May it please your lordship. Lordship, this matter relates to compassionate appointment. The appellant is agreed by the impugn order dated 9/1/2024 passed by the Honorable Single Judge, your lordship. The facts in brief are that, your lordship, the father of the petitioner was serving as a superintendent of one Hailakandi town madrasa, and he died on harness on 21/8/2012 due to cancer. Immediately thereafter, your lordship, leaving behind the petitioner and his two sisters, all of them were minor, 11, 12, and 8 years old, and their mother, your lordship. The mother thereafter applied for compassionate appointment on 8/11/2012, your lordship, immediately thereafter, which is at page number 25. The said application was forwarded by the inspector of school to the district elementary education officer for doing the needful. Unfortunately, your lordship, nothing has come out from that one. Now, this mother, your lordship, she is a Pardhanishin lady because wife of a town high madrasa superintendent, and she is also
She has applied for employment.
lordship.
How this argument of Pardhanishin lady?
No, that is what that regarding legal remedy that is required. So thereafter, she moved from pillar to post, your lordship. Her case was ultimately not considered. And in the meantime, your lordship, her son, who has attained the age of majority, your lordship, he submitted an application in 2019. And that was ultimately rejected by UF in impugn order at page number 29, your lordship.
In fact, when things of this appellant has moved an application at that time, the policy regarding compassionate appointment has already been some new policies given family pension regarding
No, that has not come. That has not come into this area.
Compassionate ground. 7 years long, they have planned for Sanjay Kumar's case. You cannot wait till he attains the majority. Let me late down to I was not a major. Yeah, that's a different matter. Did your mother approach the court at any point of time? 8, 11,
Yes, this is
2012.
also on record, your lordship, at page 25.
Yes, 8, 11, 2012. She did not pursue the matter in the court.
In the court, she did not pursue, but she went to the
Yes.
office.
She went to the office, but there is no, this did not come to the court.
Lordship.
You applied on 2019, after 7 years of the death.
By the time I attained majority.
So where is the error in the judgment?
Now, the ground for rejection, your lordship will see. The ground for rejection of the DLC at page number
14, para number 14,
page 28, your lordship.
para number 14. Applying the ratio as contained in the decision of so and so. To the facts of the, it is found that the after purported submission of the application by the mother of the petitioner also by the, there is nothing on record show the family of the eligibility pursuing the matter with the authorities and or agitated the matter on the failure of the part of the authority to consider their case for appointment on compassionate ground. Further, even if the contention of the submitted the application for appointment, compassionate only in the year 2000 is accepted.
2000 is not correct, I
Still,
think.
okay, 2019
Yes.
is accepted. Still, there is nothing brought on record to demonstrate how the matter is being pursued by the petitioner till was rejected by the district 2021. In the decision, although decision referred to also alluded there. Accordingly, it does not have merit. Still claim, that's right.
No, lordship, I am before your lordship because
Ultimately, you can't claim as a matter of right.
no, not as a matter of right, your lordship, but the ground for rejection. Lordship, the ground for
Since
rejection,
2012,
lordship.
the deceased, the death of the employee.
On
And if 2023 is more than 11 years, now you are surviving, then finding the question of financial crisis is not there. Can't, it's,
Lordship is correct, but lordship, the ground, it is not that the authority has rejected my case on the ground that I have come after much long or delay. They rejected on the ground that I was a minor at the time of submission of the application.
Is there any obligation cast on the authority to wait till one incumbent attains the age of majority?
Not your lordship, but if
It is against the law, Sanjay Kumar, Bihar case.
Lordship is correct. But my mother has applied your lordship. They have not
Mother
considered your lordship.
she had not pursued even. Now you are saying that she was a Pardhanshin, she is a Pardhanshin lady.
She has not
If she can
pursued-
apply for employment. And how can we imagine that she can't,
She has not pursued before this court. That is what is my submission, but she has moved around the office, your lordship. And lordship, the ground for rejection, your lordship, that is not tenable in view of the law laid down by this honorable court, your lordship. I have annexed at page number 59, your lordship. The impugned ground of rejection is that I was a minor at the time of submission of application.
apart from that.
But this honorable court has held that it is the date of consideration which is relevant, your lordship. On the date when they have considered I was a major. And on that ground itself, your lordship, this honorable court has, lordship will kindly see page 61. Lordship will kindly see page 61 for a moment.
2007 SCC. 2007. 2007.
2000.
Lordship will take up the judgment of this honorable court, your lordship. It has been held that you cannot reject a claim on the ground that he was a minor when you consider him when he has become a major.
We have to test the judgment from the law settled by the Honorable Supreme Court, isn't it?
Lordship.
192.
Did been a case, your lordship, that the mother also not applied, they have not pursued, and suddenly the son on became attaining majority has come up with an application.
Exactly on this facts. Exactly. Paragraph 3 they give you. The sudden presence जो आपने बोला था हाँ नागपाल
Anything else?
Lordship, the judgment of this honorable court, your lordship, that I'd like to,
What to do about the judgment of the Honorable Supreme Court?
Honorable Supreme Court, your lordship, the judgment that has been relied on by the learned single judge, your lordship.
Judgment is also there.
The facts are quite different, your lordship.
Another judgment, same applicable to this pen. Very much applicable to this. pen.
In fact, in a similar matter, your lordship, I have the judgment of this honorable apex court, your lordship.
Tax code, sir, 2000, you just.
Lordship is correct that actually undue delay generally causes.
Not undue delay, this majority and major issue
Lordship.
that has been considered here, there was a report. Para number 4. 3 eyes.
Yes, 2007.
We've gone through that.
Lordship, yes.
Para number 3.
So here, there was a stipulation that it should be filed within 5 years in that policy. And here, the widow's application was rejected without any reasons. That was the subject matter of challenge. They particularly peculiar facts and something for this case. Mm. कभी कभी क्या होगा कभी कभी क्या हो जाता
So it's only one para. पढ़ने की ज्यादा जरूरत नहीं.
This is the case, your lordship, where the minor, the petitioner was minor from the very initial stage. It is not a case where mother also applied or some other eligible members have applied. But lordship will consider this mother with 3 minor children, your lordship. She has somehow.
Sir, now what we are saying, sir, if since 2012, if they have survived, then what is the financial crisis in the family, sir?
No, if
Yes, I do understand.
that the authority will consider, your lordship. Lordship may direct
Not
that the authority will.
We will also, we can very well also assume. What
Only
to do with
this-
the authorities, if after 2012 you remained, you still survive, then there is no financial crisis in the family.
Because we'll submit,
you
we'll
can't
submit
claim-
our relevant financial conditions also before the
Can't claim compassionate appointment as a matter of right, it's a matter of policy and.
It's an
yes,
exception.
It's an exception to the general rules.
This is a case, lordship, where there is injustice done by the authority, your lordship. Mother applied in due time, your lordship. Lordship will, because it ultimately is a case of.
At that time, if your mother, has approached the court, certainly there was a case, but not now.
There are certain occasions in every case, you cannot expect a person, due to many reasons, she may not have
Sir,
been able to
many
come.
reasons, but that's why only, what are those reasons that your mother not been able to come to approach this court or any other authorities? What were those reasons?
Financial and lordship, she was the only lady to look after her child and
These very generalized.
no,
Give us some reason that for this reason she was not able to approach, then certainly would have.
secondly, your lordship, she resides from a very remote district.
Sir,
and-
remote district is, she can apply for government employment, but she can't approach the court.
No, court is at a distance of about 400 kilometers from that place, your lordship.
Absolutely, you can find.
Lordship will kindly consider the judgment of 2023 that I have given, your lordship, exactly in a similar nature, your lordship. 2023.
Okay, we'll consider.
Lordship will consider this judgment of 2023 two GLR 58, your lordship. I have
Yes.
provided.
You submit it.
I have provided, your lordship.
Okay, fine. We'll consider.
Exactly on a similar nature, your lordship. Exactly on a similar nature.
Yes.
Just I read this one and then I'll conclude, your lordship.
नहीं, आज ही लिखा था रिजर्व करना मुझे
नहीं, today's it, I will declare for the-
आज ही
This paragraph 6, your lordship, at page, internal page number 3. The facts of the present case are at a,
We'll consider.
we'll consider it.
I'll not say that they should give us compensation, but the ground for rejection that he was a minor at the time of application, your lordship, that is against the law laid down by this honorable court, your lordship, and consistently followed by this honorable court, your lordship.
Fine.
Matter may be remanded, they will consider if my financial position is not good and if lordship, I may, or on the ground of delay, they may also reject, your
We'll
lordship.
consider.
Lordship.
Item 20.
Oblige, lordship.
May it please the lordship. My lord, to NHPC, no? My lord, NHPC, National Hydel Power Corporation, my lord, they issued a tender, my lord, for doing some civil work in connection with addressing the, the downstream impact of that Lower Subansiri project. Now, what had happened, my lord, in the first round of technical evaluation as per the, my lord, tender, the appellant before your lordship, he was found to be technically responsive. And the private respondent in whose favor now the work has been awarded, he was found to be non-responsive. That your lordships will get at page number, it starts at 283, my lord. This evaluation took place on 29/11/22. Please come to page 283, my lord. And I mean, JLD to put. Now, TEC report for riverbank protection erosion control measures on left bank of river Subansiri adjacent to village so and so. Now, please come to my left, serial number 3. Brahmaputra Infrastructure Limited is the respondent number 6. And my lord, serial number 8, JLD Construction is the appellant.
Look, this is page number 283.
3, my lord.
283 is the this TEC report.
TEC report, my lord.
Here the Brahmaputra is at serial number 2.
3, my lord, 3.
Page number 284, serial number 2.
No, my lord, at page 283, first page of the TEC report.
TEC report starts from page 283.
Yes, I'm drawing your lordship's kind attention to page 283 only.
Yes, Chair.
Yes.
Yeah. Serial number
3, my lord, Brahmaputra is R6, respondent number 6, and serial number 8 is the appellant.
Yes.
Now, please come to the after serial 10. TEC duly constituted at note has gone through the technical bid submitted by the above participating bidder and has sought clarification from the bidders. The details of the clarification sought from the bidders and responses from the bidder is detailed below. Then my lord will kindly come to page number 284.
Yes.
Now, as far as respondent number 6 is concerned, my lord, they did not submit this EPF certificate, Employees Provident Fund certificate. Then eventually at page number 289, my lord. Now, Brahmaputra's bid was, my lord, evaluated at page 289. Then at page 290, serial number 10. Valid EPF certificate submitted in the name of Messrs Brahmaputra Consortium Limited, not as per NIT.
Yes.
Then eventually, my lord, at page 291, serial number 24, remark. As per above serial number 10, bidder is techno-commercially non-responsive.
Page 291.
Yes, my lord, serial number 24. As per above serial number 10, bidder is techno-commercially not responsive. And as far as the, my lord, appellant is concerned, the lordships will get at page 298. It starts at 298. And if your lordships would kindly come to page 299, serial number again 24, remark. Page 299. As per the above, bidder is techno-commercially responsive. Then at page 303, my lord, they make their final recommendation on technical bid evaluation. Recommendation at page 303. To open the price bid of the following techno-commercially responsive bidders, serial number 2, JLD, that is the appellant. B, not to open the price bid of the following techno-commercially non-responsive bidder, serial number 3, Brahmaputra. Now, I would like to draw your lordship's kind attention to some of the tender conditions, my lord, as to under what situation any clarification can be sought for. My lord, may kindly come to page 123. I'll have your lordship's kind attention to clause 16.4, 18.1, 18.4.
Just a minute, just a minute.
Yes, my lord.
Yes. Sixteen point four.
16.4, 18.1, 18.4, 21.3 and 21.4. My lord, may kindly come to page 123,
Yes.
16.4.
Yes.
Any alteration, modification in bid or additional information supplied subsequently to the bid after the period of bid submission, unless the same has been expressly sought for by the employer,
shall be disregarded.
Yes.
18.1. After submission of the bid, contractor can resubmit revised bid any number of times, but before the stipulated deadline for submission of bid. 18.4. No bid shall be withdrawn or modified, revised in the interval between the bid submission deadline and expiration of the bid validity period specified in the bid document. Withdrawal or modification of a bid during this interval will result in bidders forfeiture of its bid security, and further their bids shall be considered non-responsive. Then my lord will kindly come to page 125. Twenty-three point one, 21.3. Or before that, my lord, I'll have your lordship's kind attention to clause C of 21.2. Please come to page 124 for a moment, my lord. 21.2. A substantially responsive bid is one which conform to all terms, conditions, and specifications of the bidding document without material deviation or reservation. A material deviation or reservation is one. Please come to C. Whose rectification would affect unfairly the competitive position of other bidders presenting substantially responsive bid. If this seeking of clarification amounts to, my lord, altering the position in the techno-commercial bid, my lord, that in my humble submission cannot be permitted. Then 21.3. If a bid is not substantially responsive, it will be rejected by the employer and may not subsequently be made responsive by correction or withdrawal of non-conforming deviation or reservations. Then 21.4. During techno-commercial bid evaluation, the employer may at his discretion ask any bidder for a clarification of its bid. The request for clarification and response shall be in writing or email or through portal. However, no change in the price or substance of the bid shall be sought for, offered, or permitted. That means, as regards the substance of the bid is concerned, if our mandatory document is not given after the due date of submission of bid, that cannot be asked for and made the bids substantially responsive. Sometimes, my lord, there are certain areas where, my lord, it may not affect the relative position of the bidder. In such a situation, that discretion has been reserved to the employer. But the moment seeking of a clarification results in altering the position in merit, that cannot be done. Now, my lord, on the face of this clause in the tender, what the authority did, my lord? Page number 351. Page 351. Kindly mark the date. 13/10/22. And last date of submission was 30/8/22. This is in reference to the above subject matter.
Page 3.
Page 351, my lord.
Yes.
This is in reference to the above subject matter and the tender submitted by you. In this connection, you were requested to submit the following document. EPF certificate in the name of Brahmaputra Infrastructure Limited. You were requested to submit the above requisite document within 7 days from the date of issue of this letter through email and followed by original through post, failing which your offer will be evaluated on the basis of the available documents submitted with the bid. Whether under this scheme of the, my lord, bid document, this is permissible, my lord. This is sheer favoritism. Now, a similar letter was issued to the appellant also, but that was neither here nor there. I have already been adjust technically responsive. My letter is at, my lord, page 353. Page 353. This is in reference to the above subject matter and the tender submitted by you. In this connection, you are requested to submit the following documents: power of attorney along with copy of the board resolution for the instant NIT, contractor registration certificate class 1 or 2 issued by the government semi-government department as per NIT. Well, I may actually start up.
That evaluation
Yes.
at page 303
Yes, my lord.
was done on which date?
That was done on 29/11/22.
29/11/2022. That is prior to issuance, that is after issuance of this letter.
Yes.
29.
And even they have taken note of that. At page number, my lord, 1 second. Yes, please come to page 283, my lord.
So whether this respondent number 6.
Yes.
He has submitted this.
No,
certificate.
no, he did not. What they did, my lord, they supplied some, some invoice was submitted, not the registration. Invoice of paying some money to the department. Not certificate. Please come to page 283, my lord. The authority takes note of that. By their own letter, since it was not submitted, it should have been evaluated. Kindly see at page 283. Just after serial number 10, towards bottom, TEC duly constituted has gone through the technical bids submitted by the above participating bidders and has sought clarification from the bidders. The details of the clarification sought from the bidders and responses from the bidder is detailed below. Now at page 284, EPF certificate not submitted. Now in that letter of 1310, they say also, if you do not submit, then we will go ahead with the evaluation without the document. And they did it on 29/11/22. Thereafter, my lord, they have taken note of a document which was supposedly in their department itself. That your lordships will get at page 304. On 10/12/22, this was done.
304
Yes.
is of 5th of August 2000.
No, my lord, it is no. Actually, if your lordship kindly comes to the next page, the signature is 10/12/22. 5th of August is the date of the tender, my lord. NIT is dated 5/8. Can I have have to paragraph 2, my lord? Brahmaputra Infrastructure Limited, the firm had not submitted EPF certificate in the name of the bidder, that is Brahmaputra Infrastructure Limited, as required against clause 3.2 BI. The firm was asked to submit the same. Against the same, the firm has served a copy of the EPF challan, only wherein the name of the firm is mentioned as Brahmaputra Infrastructure Limited, that is in the name of the bidder. During deliberation, the committee was also informed that bidder Messrs. Brahmaputra Infrastructure Limited has submitted a document issued by EPFO, the Regional Office, Delhi, regarding the change in the name of EPF registration from Brahmaputra Consortium Limited to Brahmaputra Infrastructure Limited. In the tender document for the work, river bank protection erosion control measures on the left bank of river Subansiri upstream, so and so dated 10/12/21. The committee opines to consider the same towards qualification of the bidder in this tender. In view of the same, the firm qualifies the tender conditions of the NIT. The TEC recommends to consider the bid of Brahmaputra Infrastructure as responsive. then my lord, the tender is not required. So many documents are with the department. Now, this is the case, man. Now the work has been awarded to them. They have performed substantially also. But in terms of the affidavit filed by the NHPC, my lord. They say by 15th of March, the work was supposed to be over. Now, my question is, my lord, if a wrong has been done to me, then I'll sue them in civil court for damages.
That is always open.
No, lordship will record a finding in this case that this acceptance of the tender was wrong. That will give me a fillip to my
Then
claim,
what the civil court will do?
my lord.
Then what the civil court will this ascertain the
No,
damages?
no, civil court will quantify the damages and all.
Quantify.
Yes. Now, my lord, I'll place one judgment. Let us see what view Honorable Supreme Court has taken.
First of all, we would like to see the finding
lord.
of the learned single judge.
Yes. My lord, the impugned judgment, it starts at page 52.
Refer to internal page of the judgment.
My lord will kindly come to page 10.
Page 10. Yes.
Or my lord may kindly come to page 64, para 18, para 13 internal.
Para 13.
Internal, my lord.
Page
Yes.
13. Not
Yep.
para, page 13.
As a page,
I'm sorry, page 13, para 18. The petitioner has utterly failed to demonstrate that by granting opportunity to 6 out of the 10 bidders to provide clarification document, there was any intention of the tendering authority of the NHPC to favor any particular bidder. The decision taken by TEC thus cannot be held to be bad in law. In view of the herein before referred clause 16.4 of the ITB and clause 5.4.5 of Government of India Manual 22, which permits tendering authority, that is TEC, to seek additional information, clarification and shortfall document, the court repels the contention of the petitioner that by such action, non-responsive bid of respondent number 6 was made responsive after the deadline. The court is inclined to hold that the act of TEC tendering authorities of the considering the additional document produced by respondent number 6 was not in violation of clause so and so of the ITB. As the learned senior counsel for respondent number 225 has been able to successfully establish that petitioner is also granted an opportunity to furnish as many as 3 distinct documents which are more fully referred to herein before, the absence of which would have made the bid of the petitioner as non-responsive. There was no occasion, my lord. I was already made responsive. It cannot be acceptable that similar decision
you were made responsive
prior to that.
after submission of those documents which they sought on 13/10/2020.
No, my lord, those documents are not even taken note of. Yes, date-wise, if we go, because the letter was 13/10 and the consideration was of 29/11.
In the absence of those documents,
My lord, that is
even though in the absence of those documents, you
yeah, I'm through. Yes. Yes, at least from the column which the authority, the TEC took note of, it does not refer to any, resolution of the company or, my lord, any certificate, nothing. The so and so which are more fully referred to in above, absence of which would have the bid of the petitioner as non-responsive. It cannot be acceptable that similar decision taken in respect of respondent number 6, allow it to produce or provide.
that this observation made by the learned single judge is wrong.
In my humble submission, wrong, my lord. My lord, if this is the view, then my lord, Article 14 we cannot give a meaning to Article 14. My lord, so therefore the view of the learned single judges, it's not that only the respondent number 6 who was asked to clarify. It was our client also who was asked to clarify. Therefore, now it doesn't lie in our mouth to make such an argument. That is in substance is the finding. My lord, I'll place one judgment of the Supreme Court. If your lordship would kindly, এখন দিয়কচোন judgment দুটা। Please come to para 26, page 17 of the judgment. Para 26. In West Bengal State Electricity Board versus Patel Engineering, this court, while considering the issue with regard to the process of tender held, where bidder who fulfills pre-qualification alone are invited to bid, adherent to instructions cannot be given a go-by by branding it as an pedantic approach. Otherwise, it will encourage and provide scope for discrimination, arbitrariness, and favoritism, which are totally opposed to the rule of law and our constitutional values. The very purpose of issuing rules instruction is to ensure their enforcement, lest the rule of law should be a casualty. It was further held, the contract is awarded normally to lowest tenderer, which is in public interest, and that it is equal in public interest to adhere to the rules and conditions subject to which bids are invited. Following the aforesaid legal principles laid down by this court, we are of the considered opinion that respondent number 1 was negligent and was not sincere in submitting his pre-qualification document within the time schedule laid down, despite the fact that he had information that there is a time schedule attached to the notice inviting tender. Despite being aware of the said stipulation, he did not submit the required document within the stipulated date. The pre-qualification documents were received by respondent number 2 university only after the time schedule was over. The terms and conditions of the tender as held by the Supreme Court are required to be adhered to strictly. And therefore, respondent number 2 university was justified in not opening the tender submitted by respondent number 1 on 1/12/2008, which was late by 3 days. According to us, no grievance could also be made by respondent number 1 as lapse was due to his own fault. Now today, my lord, for example, if the tender of respondent number 6 would have been rejected, and he would have come before this honorable court saying, I am having this document, but they have not accepted it, but sorry, I could not give it. Then, my lord, what view this honorable court will take?
Would have come before this court with the argument
Yes.
that this, whatever the requirement or whatever the document was there, that was already with the department. And department has not taken into consideration of it.
No, my lord.
Because in the acceptance order, which you have referred to.
The second TC report.
That is a second TC report.
Yes, yes.
In which they have specifically mentioned that this document was very much there.
No, my lord. No, here in this case, he was here also in this case before the Supreme Court, he was only late in giving the documents. So Supreme Court says he was negligent because, my lord, otherwise, my lord, what meaning do we give to these tender conditions? What meaning we give to the last day? If this type of leeway is given to the authorities, then, my lord, they will do all sort of, subterfuge. My lord, nowadays the law is very clear. Even, my lord, it's a different matter that now the interpretation which is sought to be given by the Honorable Apex Court is that power is very restricted. Only in a case where it will result in failure of justice, then only court should intervene. Now, here is a case, admittedly, a non-responsive bidder by their own account. He was just non-responsive even after giving an opportunity. My lord, kindly imagine a technical bid evaluation committee has set for the second time to make a non-responsive bidder responsive. It was at whose request? It must be at the request of somebody. Who is that somebody? Is it the power of review they were exercising?
They have not only considered the case of the respondent number 6 alone, they have also considered this Silpi Intracon.
No, my lord.
His case was also
If consideration qua respondent number 6 is bad, then it will be bad qua that Silpi also. No, my only humble submission is, my lord, after the last date, the tender condition says, especially 21.3 and 21.4 says, you can only seek those information where the relative standing of the bidder will not be altered. If the relative standing of the bidder stands altered, then in my humble submission, my lord, a non-responsive bidder cannot be made responsive. I think that's the law in West Bengal, that's the law in this Sorat builders, my lord. Because here also a pre-existing document was there. Supreme Court says you were negligent, you were there by 3 days only. Now we can't take it.
Instead of this clause, would have given the certificate. 21.4. Which is the leeway given to the employer. Now, that should not make any change in the price or substance of the bid.
এখন দেখছেন 1994 6 SCV 651.
Yes. And that is clear noted because there was some change in the new edition. So therefore, maybe there was some error in giving the APF certificate.
651. Well, I would like to refer one paragraph from Tata Cellular, my lord.
Just a minute. But sufficient APF, so if there is no change in price, they don't change substance. Competition. Competition does the national price comes first.
Yes. My lord, one paragraph from Tata Cellular. My lord, may kindly have page 677, para 77.
Yes.
The duty of the court is to confine itself to the question of legality. Its concerns should be: 1, whether decision-making authority exceeded its power, and 5, abused its power. I'll respectfully submit, my lord, this was the contour which was laid down by the Honorable Apex Court. These 1 and 5 would be attracted in this case. Whether decision-making authority exceeded its power in, my lord, having the second TEC, that too based on they asked for the document was not forthcoming. Then of their own, they could find out, oh, in such and such contract that is of 21, it is lying. So we will consider that.
No, it is pointed out by the respondent number 6.
No, my lord.
On their own, they have not taken.
Of their own, my lord.
Not.
Of their own. See, my lord.
Page number
Yes.
304.
304.
Committee was also informed.
During the deliberation, the committee was informed.
By whom?
Bidder has submitted a document issued by a. It was informed that he has submitted a document. This respondent.
No, my lord, it's very strange, my lord. In a TEC, who has informed? They must say it, my lord. Otherwise, my lord. Otherwise, my lord, this
various sources, sir.
No, my lord. With all respect, we can't, take these things lightly. My lord, That is very intriguing, my lord. How can there be a someone whose name is withheld? Well, they were sitting with a particular file. How they were aware that in another file it is there? My lord, some genuine source, my lord, they could not have taken note of this, my lord. That's my humble understanding. Anyway, that is my humble case, my lord. Therefore, it's a case on account of, my lord, the fact that the work has progressed almost substantively, even if your lordship is not inclined to interfere with the work order, but lordship will definitely record a finding regarding the manner in which the contract has been awarded, and as a result, how my rights have been interfered with, so that my lord, I can seek compensation in the appropriate forum. Because lordship will have to weigh the public interest also. In fact, in one such case, it has been done by this honorable court. Coincidentally, my lord, no. এই যে তোমার অখণ্ড দেখা যাবে। I think toughest case, yes. Some tractor supply case was there because in the meantime, my lord, the contract all was performed to a large extent. Therefore, this honorable court made the declaration that award of the contract was made, that a wrong has been done and liberty has been given to us. My lord, if your lordship wants, I can hand over the judgment tomorrow, my lord.
No problem.
So that is my humble submission, my lord. Otherwise, my lord, this rule of transparency will lose all its meaning, which has been emphasized by the Supreme Court in Patel Engineering's case. Deep level.
Just a minute. What is it? 22. Which is not the case.
My lord, I got the citation of the other case which was dealt by this honorable division bench of this honorable court, my lord. I'll hand over a copy tomorrow. That is 2022 3 GLT page 41.
First and two में तो इसको तो होता नहीं है. It is inconsistent.
Essentially non-responsive. Essentially responsiveness, non-responsiveness different here. This is not the definition non-responsive. In document the improper services, it was not found, and there was change in name of some circumstances across scripture. So here infrastructure. There is no change in no variation. Once the question was asked, created in a which is between Finally, he was treated.
Yes. Lord, I appear for NHPC. Lord, I demonstrate that NHPC in the course of decision making process, the law, they follow transparency, there was level playing field, and there was no favoritism whatsoever towards the respondent. That could be my endeavor. Now, my lord, on the previous occasions when this case came up, I had given the sequence of events, because sequence of events are very, very important. On which particular date this document was given by whom, and how did we communicate to the bidders? When you So, submitted. it was given, my lord, again, my lord, I am giving additional copies. Copy was handed over to my friend on the earlier occasion, the same copy I am placing. It's not on record. No, my lord, we'll just see the sequence. I'll just place it. Number 5822. I'm sorry. Yes. 5822, my lord, is the date on which NIT was issued. The last date of submission of bid was 30th of August 22. I'll escape it. I will not go deep into it. Then we got 5929, bid of 10 bidders, including that of the petitioner, that is appellant, and respondent 6 Brahmaputra Infrastructure were opened by the tender opening committee and checked by tender evaluation committee. So, my lord, we have this tender opening committee and tender evaluation committee. Two committees are there. So, the bids were checked by tender evaluation committee. So far as the appellant is concerned, my lord, appellant had not submitted power of attorney and board resolution with the tender as required under clause 3, 1A of the NIT. The page 92 of the triple book, my lord, you will see the exact clause. These are all essential conditions, essential qualifications for a bidder. And also class 1 contractor registration certificate issued by government, semi-government department is required under clause 3 to AC of the NIT. So the appellant had not submitted this. We found that. And so far as respondent 6 is concerned, Brahmaputra Infrastructure Limited had also submitted with its bid an EPF registration number in the name of Brahmaputra Consortium instead of Brahmaputra Infrastructure Limited, hereby not complying with the requirement of clause 32B1 of the NIT. For a moment, also you may see clause 32B1 of the NIT at page 92 of the paper book. Page 90. There is a reason why I am showing it. B1, page 92 exactly at the bottom. Yes, 32B reads, each bidder must also produce with their bid, 1, PAN number, GST registration number, and EPF registration number. Not entire process is online. Requirement is the number, and normally what is the process that we follow? If we get the number, whatever number you give, that number we go to the portal of the Government of India and we verify whether this is correct or not. Now the number which they had given, that number was against Brahmaputra Consortium, not the Brahmaputra Infrastructure. So this was the defect so far as respondent 6 is concerned. And so far as petitioner and the appellant is concerned, the two important documents they had also not given, which is an essential condition qualification for a bidder. Likewise, my lord, there were 4 other bidders. Their bids were also deficient. The other bidders also, my lord, their bids were deficient, but the defects were very, very major in their case. So, my lord, opportunities were given to 6 bidders, including appellant and the respondent 6. So, my lord, this 29.922 I will skip the power that we exercise. But for a moment, I will just show, namely, paragraph 5.4.5 of the manual, NHPC manual. This is, my lord, quoted by learned single judge. It is for this purpose that we ask for the documents. 5.4.5. This, my lord, will find Page 57 of the paper book. It is part of the judgment. Page 57. Learned judge has quoted it in extenso. It is internal page 6 of the judgment. Internal page 6, paper book page 57. Yes. I read 5.4.5. Clarification of bids. Shortfall documents. During evaluation and comparison of bids, the procuring entity may, at its discretion, ask the bidder for clarification on the bid. The request for clarification shall be given in writing by registered speed post, asking the tenderer to respond by a specified date, and also mentioning therein that if the tenderer does not comply or respond by the date, his tender will be liable to be rejected. Depending on the outcome, such tenders are to be ignored or considered further. No change in prices or substance of the bid, including specifications, shall be sought, offered or permitted. No post-bid clarification at the initiative of the bidder shall be entertained. The shortfall information, stock document should be sought only in case of, this is important, only in case of historical documents which pre-existed at the time of tender opening and which have not undergone change since then. So, documents they are already in existence at the time when you submit your bid, and we can ask for those documents, clarify this. You can't introduce a new document which never existed and which came into existence after submission of the bid. That is not allowed. So prehistoric or historical documents which pre-existed. These should be called only on the basis of the recommendations of the tender committee. Example of such as the such as. So far as the submission of documents is concerned, with regard to qualification criteria, after submission of the tender, only related shortfall documents should be asked for and considered. For example, if the tender has submitted if the bidder has submitted a contract without its completion, performance certificate, the certificate can be asked for and considered. However, no new contract should be asked for so as to qualify the bidder. So, it is under this we exercise the power. Then, accordingly, so far as they are concerned, I will skip that because initially the draft letter was prepared on 29/9, which they annexed with their writ petition. On 13/10/22, we issued emails. Emails were issued to all 6 bidders, including appellant as well as the Mr. Tiwari, just a minute. In this TEC report at page this 283. Yes. This you have mentioned that this respondent number 6 has not submitted this EPF certificate in name of not submitted. The respondent 6 had not given had given the EPF registration number on the name of Brahmaputra Consortium. Whatever you have simply mentioned EPF certificate in the name of Brahmaputra Infrastructure Limited not submitted. Yes. This is what. Then, in relation to this petition, this appellant. Yes. At page number
285.
298. 298
and 299.
You have not pointed out any deficiency in respect of this appellant JLD Constructions, page 298. You have not pointed out any deficiency. Yes. This will not, I can. Yes. No, white letter dated 13/10/2022, I asked them to furnish further information in respect of something. But why in this TC report? I don't know what is the date of the TC report?
It is 29/11. The TC report, my lord, is dated. Just a minute. 29/11.
This is 29/11. No, it is not 29/11.
My lord, it is 29/11. That's why I'll explain with the sequence of events.
Okay, then 29/11.
Yes.
In this, you have not even referred about those documents which
Yes,
you have
because by that
asked.
time, that is by the sequence. By that time, the applicant, in response to our email, submitted the required documents. That's why it may not the sequence.
So, sir, here,
Yes.
this respondent number 6 has also submitted the required
Yes, he
documents.
submitted online, my lord.
Then-
They all
then
submitted
why-
online.
Just a minute,
Yes.
then why you have mentioned here that BPEPF certificate in the name of Brahmputra Infrastructure not submitted?
My lord, that is the mistake that we had committed. It was very much
No,
submitted.
not the case.
And that is why I will produce the minutes. I produced the entire minutes of the proceedings. Before the rendered single judge, I will show the same thing before the lordship. It was online, it was not noticed, and this mistake was detected when the financial concurrence process was given. Because at the stage of the financial concurrence, my lord, entire scrutiny is done all over again. And then they pointed out that you have already committed a mistake. I'll show with the help of the minutes. As to how the notices were made, entire sequence is there, my lord.
Show us. Sir.
Yes. Okay, could I not finish the sequence?
You just show us that what are the minutes? You just want to specific dealing with this point.
Yes. My lord will see from page 20.
Even after clarification.
Yes, page.
Page 20 onwards. From page 20, we are dealing with the relevant case.
Yes.
The entire sequence my lord will get. It's both in English, it's my lord, in between it's Hindi.
Yeah,
If for my lord, Justice Mehdi finds it difficult, I will give English translation.
I'll assist him.
Yeah, very good.
I'll assist him.
So note 61. This is it. तकनीकी तत्काल मामले में 10 बोली लगाने वालों में, so 10 bidders participated in the bid is being mentioned. Then निम्नलिखित तकनीकी व्यावसायिक रूप से उत्तरदायी बोली करताओं की मूली बोली खोलने के लिए 2 the recommendation 2 SIPL Infracon and JRD Construction.
Yeah,
This is the law. And then निम्नलिखित तकनीकी व्यवसायिक that is techno commercial bid. यार उत्तरदायी बोली करताओं की मूल्य बोली नहीं खोलने के लिए. So Brahmputra Infrastructure figures at 3 respondent 6.
Yes.
Not to open.
Yes.
Then my lord, this is my lord will find from assistant manager procurement and contract, next page 21. It goes to senior manager contract and procurement. Then it is recommended by general manager procurement and contract. Recommended 1/12/2022, note 63. The approval is given. Then my lord, it comes to executive director. Note 64 ED, note 64. Executive director, it comes to him. Now, ED, my lord, as per the procedure, he refers it for financial concurrence. So, my lord, he forwards it to general manager finance at 65.
Yes.
65 is a portion, it comes to general manager finance. Then, my lord, scrutiny is done of all the papers and documents. Note 66. Then, my lord will find the note of manager finance.
Yes.
Which is very relevant. उपयुक्त कार्य river bank protection erosion control measures. You know, I think I have made the English translation also. I can read, but my lord, this is
No, my lord is also comfortable. Not
well. उपयुक्त कार्य सच एंड सच पर रखी टेक्नो कॉमर्शियल मूल्यांकन रिपोर्ट की स्वीकृति के संबंध में पूर्व प्रश्नों पर दिए गए प्रस्ताव को वित्त विभाग में जांच किया गया. डीसी ने सच एंड सच पॉइंट ए पर उल्लिखित 2 बोली दाता की बोली को टेक्नो कॉमर्शियल रूप से रेस्पॉन्सिव पाया है और उनकी प्राइस बिड खोलने की सिफारिश की है. और CP 2070 के पॉइंट बी में 8 बोलीदाताओं की बोली को नॉन रेस्पॉन्सिव पाया है और उनके प्राइस बिड को न खोलने की सिफारिश की है। दस्तावेजों की जांच के उपरांत ये पाया गया कि मिसेस SIPL Infracon एक पार्टनरशिप फर्म है, तो SIPL never came before the honorable court, so this part I'll escape it. Mrs. Brahmaputra Infrastructure, now we come to respondent 6. Mrs. Brahmaputra Infrastructure Limited ने EPF registration certificate Mrs. Brahmaputra Consortium Limited के नाम पर जमा किया है। इस बाबत स्पष्टीकरण मांगने पर EPF registration certificate की जगह EPF चालान संलग्न किया गया है। संलग्न किए गए चालान से यह ज्ञात होता है कि एस्टैब्लिशमेंट कोड एवं नाम DLCPM 0035337000 ब्रह्मपुत्र इंफ्रास्ट्रक्चर लिमिटेड के नाम है। अतः वित्त विभाग के अनुसार इस बिडर के मूल्यांकन की पुनः समीक्षा का सुझाव।
So you declared that this, whatever the general finance has declared a responsive bid as non-responsive, that of CP Infracon Private Partnership Limited.
SIPL, yes. SIPL didn't come before the honorable court.
No, not come before the honorable
And
court, but here,
Brahmaputra Infrastructure,
just
you review.
just a minute.
Yes.
Earlier you found two bids were responsive.
Yes.
One is by SIPL, another by JDL Appalachia.
Then
Now,
we found that
This
SIPL
general
is not responsive.
general manager finance has found that this SIPL is not responsive, whereas Brahmaputra's case is required
Yes.
reconsideration.
Yes. JLD became responsive because in any case they submitted the right document. When asked for. And we also submit that respondent 6 also submitted the document which was ignored, not looked into, then manager finance caught the mistake and pointed out, no, it was very much there. So it is to be, then general manager finance will not, he clears it. उपरोक्त चार्ट अनुसार की निविदा मूल्यांकन की समीक्षा आवश्यक है. So he says it is necessary to review it. This is a mistake. Then it comes to executive director, will not, he clears. Executive director clears it, note, it comes to general manager, PNC, note 70, then Milord, note 71. वित्त विभाग के द्वारा नोट 67 पर की गई टिप्पणी के आलोक में टीसी ने अपनी तकनीकी व्यावसायिक व्यवहार्यता की 2 बोलीदाताओं का पुनः मूल्यांकन किया है। उसी के लिए टीसी की रिपोर्ट क्रम संख्या सचल सच टीसी ने निम्नलिखित सिफारिश की है। निम्नलिखित तकनीकी सचल सच ब्रह्मपुत्र NGLD की बोली खोलने के लिए निम्नलिखित तकनीकी व्यावसायिक रूप से गैर उत्तरदायी बोलीकर्ताओं की मूल्य बोली नहीं खोलने के लिए केवल प्रस्तुत।
So you gave a this bid of less amount than this appellant?
Yes, my lord, respondent 6 is L1. Once we open the price bid, thereafter price bids are also opened and price bid found that respondent 6 has quoted less. He is L1, respondent 6.
The dates of this consideration of this file, movement of file, exact dates?
Because dates are written under the notes.
112, 112, 112.
Under the notes. And timing is also given.
Yes.
Timings are also given. Since I had done the English translation, so I'm also, at least this is maybe would be beneficial. So here in the sequence, my lord, I'm sorry.
Yes.
So in the sequence of events, my lord will find on 13/10/22, we issued emails, even dated emails to all the 6 bidders. On 14/10/22, the next day, respondent 6, that is my lord Brahmaputra Infrastructure, via email submitted an EPF challan in the name of Brahmaputra Infrastructure Limited. We annexed it with our affidavit in a position, or may have a look. R4 of the AIO, page 354, 355 of the paper. I'll show it to you now. Page 354 and 355. The requirement is the number. We verify the number by going to the portal, the correctness.
Yes.
Here ballot will find the number, page 355, right hand side, top, establishment code and name. Because while paying our dues to the EPF organization, this is the format we give the. Subsequently, my lord, the Chief Justice asked for the production of the certificate, that also we submitted. But requirement is the number DLCP M 00-35337-000, Brahmaputra Infrastructure Limited. And we verified this from the portal of the Government of India, EPF. This is correct. And this was the requirement. And one more, in addition, I'll just point out, this was also discussed before the Honorable Court. This bidder, NHPC has been dealing with this very particular bidder, respondent said. It had performed earlier contracts also. So in connection with the earlier contract, certain papers were there. There was a letter in the earlier contract written by this respondent says that we are changing our name from Brahmaputra Consortium to Brahmaputra Infrastructure. So that information was available with the organization. The moment we checked this Brahmaputra Infrastructure, this is the DLCP number. We verified from the portal and we had the previous information. We linked the two and we cleared it. Otherwise, there would have been a single tender. And it is not that JLD was not responsive. JLD remained responsive. So 1410, respondent 6 submitted via email. Then on 2010-22, 6 days later, petitioner and appellant, he submitted those two documents. These documents came later. Then on 29/11/22, TEC 6. But unfortunately, TEC makes a mistake and document which was submitted by respondent 6 via online is ignored. Whereas the document of appellant were duly noted. As a result, Malad has found in this very particular TEC recommendation.
What about para number 20 of this judgment? Internal page 13.
Para 20.
As the learned senior counsel of the respondent number 2 to 5 been able to successfully establish that the petitioner was also granted opportunity to furnish as many as 3 deficiencies which are more fully referred here and above, the absence of which would have made the bid of the petitioner as non-responsive.
Yes. Correct.
Saying that even though if you would not have submitted those documents, bid was responsive.
It's essential condition of it. I'll just show it.
Lordship, in the first TEC, Lordship, very sorry, very sorry.
13/10/2000.
Page 92 first, 3.18, page 93.
Page 92.
Yes, of the paper.
Yeah.
318.
318.
Eligible bidders. This is the below the criteria of eligibility.
Qualification of the bidders.
Yes, below. Qualification of the bidder. 318.
Yeah.
All bidders shall include the following information and documents with their bids in qualification information unless otherwise stated in the ITB. Copies of original documents defining the constitution of legal status, place of registration, and principal place of business. Written power of attorney of the signatory of the bid to commit the bidder. This information was not there, he did not submit.
Which information?
318.
Copies of the
Constitution and
original.
legal status and power of attorney.
Okay.
This was not there. 318. Pointed out.
And another.
I had not submitted power of attorney and vote resolution.
And another.
And the second one, is 3.28C. 3.28 3.2 capital A to qualify for award of the contract, each bidder should have 3 to AC. The bidder must be a registered contractor with any government, contract this certificate, allowing for undertaking of value, class 1 or class A as the case may be, shall be submitted along with the bid. This was also observed.
He was supposed to submit a certificate of registration.
And of class 1 and is certificate or class A of the contract. This was not submitted. Because when we send an email, he responded by submitting these two documents. It was right there.
In the absence of it,
He would have been disqualified. Not responsible. He became responsible because he submitted and we gave him the responsibility. That is why DC noted, yes, document submitted is responsible. But respondent says remain unresponsible because documents are not. Because submitted all.
Yeah.
Your holding of 29/11/2022 was after seeking of the clarification, where both the parties had issued the clarification. The appellant's clarification you have taken into note, the respondent number 6 clarification somehow missed out.
That is why this defect was noted and this came from financial conference. When this piece was going on, everything was noted. The financial conference part about very negative.
This code number is already listed. Therefore, you have to reconsider this. This is what he has noted. He has submitted that. Where is that TC further report after page
304, I think 304.
304.
Revised report.
You just see this. And then they found that only see the thing that the phone number is only there and
Infrastructure.
so this that with his bill is that he treated as non responsible here.
Yes, submitted any document is legally anything. That's why only 19, 12, 20, 11, 2020 उसको remove list में मुझे include कर दिया है. This document is already there. This document is already registered.
Infrastructure.
Infrastructure. That's why we did.
After anticipating the financial conference, management finance, all the scrutiny of documents, rejected the state. Forwarded it to general manager finance, understand, review, and that review was recommended, approved by executive director. Then the PEC said, taking note of all the details. So it is NFPC acknowledging it on the state and correcting. So the most important part is providing them with the opportunity price in email. Appearance submitting a document.
The problem is that in the earlier meeting of or the minutes of the meeting 29/11/2022, you have not referred to those documents which he has submitted in response to, which appellants have submitted in response to the email dated 13/10/2022. You have not mentioned any, you have not whispered about those documents.
Answer, once he submitted the document, those documents became the part of this bid. Once they became part of this bid, we are looking into everything and we are finding a bid. This is the answer. This is the procedure they follow. They don't mention that all our communication, the document was sent. Because it is before setting of the, initially this tender opening committee. So tender evaluation committee, email is issued, documents are complied, PC looks into all documents and
In the second report, they should have a they should have had a consideration on the bid of just a minute. Just a bit. On the bid of the appellant also, because they are also required to clarify, just like they discussed about the response number 6 bid and held it to be responsive or SIP for that event. What about the clarification they had sought and it was clarified? They thought before you come to the conclusion here, holding GLB to be responsible. No, do document board resolution. Correct. Yes. 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 Then taking into consideration those clarification, his bid was treated as responsible. But there has to be some, actually some minor that. There is no discussion.
yes. But my lord, the chief justice is seeking is there.
Where?
Also, you will see page 283.
283.
283 first. At the bottom.
Yes.
PEC duly constituted such and such has gone through the technical bid submitted by above participating bidders and has sought clarification from the bidders. The details of clarification sought from bidders and responses from the bidders is as detailed below. In respect of below appellant's name, my lord will find at column 5. Page number 284, column 5. Clarification sought first column, response from bidder second column.
Power of attorney.
Clarification sought. 1. Power of attorney along with copy of the board resolution for the instant NIT tenders. Next column submitted. Then contractor registration certificate class 1 or class A issued by government semi-government department as per NIT ITB clause 3 to AC submitted. These two documents they had not submitted. Not for submitted. But unfortunately, my lord, there was a mistake. That's all.
ये तो again not submitted. नहीं, the clarification मालूम है submitted. You mentioned it in the final deliberation. Deliberation में they have not mentioned it.
This is third one seeking of verification. It was on 13/10. Okay. So 29/11 बैठकर इसको हम फिर इसको रिजेक्ट ही कर देते हैं फाइनेंस जब बोला कि नहीं
ठीक है, that's fine. हो गया, Yes.
So my lord, unfortunately, in respect of respondent six, this mistake was made. Fine. Because the requirement was the number only. We could not verify with the name, the number. Then number came, we verified it. Fine, that is all.
Lordship, my only three things, Lordship. Lordship, if that document was there with them, Lordship, why did it not produce, Lordship, when it was?
Document?
The document, Lordship, the registration certificate, if it was there with the respondent number 6, why he did not produce on 13?
It was not there with the respondent. In fact, what this meeting notes are there, it was not with the respondent, but the general manager finance has found or come to the conclusion that in the challan there is already a code number and the name of the company.
Very well, Lord.
And therefore it is already registered with the EPF or whatever it may be. It is already registered. This Brahmaputra infrastructure company is already registered because in the challan, the code number and the name of the company is reflected.
Exactly, Lordship. In that case, Lordship, assuming Lordship, that is a fact, Lordship. Lordship, may I point out, Lordship, kindly see the Lordship, page number 355, just for a moment, Lordship, the name.
And it is not the case. In fact, the finance manager has he was of the opinion that one company which you treated as a responsive is non-responsive. And you have to reconsider the review, whatever the bid of this Brahmaputra Infrastructure Limited, in view of the fact that it is already having a code number and registered.
But
That is what they have.
Categorically on by later dated 13/10, Lordship, they have sought for the EPF registration certificate, Lordship, which they have not produced, Lordship. That's a limit to the code.
Ultimately, it is your case that they obtained this registration certificate after the last date of submission of the application. Is it your case?
No, Lordship, that is not my
That is
case,
not-
Lordship.
It
but
was very
seeming-
much there.
Lordship,
They
that
were
is not-
already registered.
Lately, but not the least, Lordship, we found the anomalies, Lordship, in the EPF registration certificate also, Lordship, which I'll show, Lordship, page number 355. Kindly it may turn, Lordship. 355. That this is the invoice, Lordship.
355.
Yeah, this is the invoice from where they have got to know the establishment code and code
355 what?
of the appeal memo, Lordship. Kindly see, Lordship, they have been verifying, Lordship, again and again, but they failed to verify the main thing, Lordship. Kindly see the name. It's not Brahmaputra, Lordship. It is Brahmaputra. Lordship, why I'm saying, Lordship, because there is one more company is there, Brahmaputra Infrastructure, which and where they have a different establishment code that we have brought on record by way of an additional affidavit, Lordship.
Have you filed any rejoinder to it, that this document was itself or any counter in that?
Lordship, we have filed an additional affidavit, Lordship, on 3/10/2023, in page number 407,
They
Lordship.
have done their research. It was, these materials were not before London single judge.
That I accept, Lordship. It is late, but we found the anomaly, Lordship. Page 407, Lordship. This is the company, Lordship, Brahmaputra Infrastructure, and they have a different establishment code. Kindly see NEGHY. This is totally a different establishment code. 407. sir.
Where do you get the code, Mr. Das?
Lordship, this is from the Employees Provident Fund
No, no,
Organization
where is the
website.
code number? Where?
Lordship, establishment code just 407.
Page
407, Lordship.
Page 407.
407. It's an additional affidavit, Lordship. Affidavit in reply, Your Lordship. I'm just paying, Lordship, may take note of this also, Lordship. Page 407.
Yeah.
There is an establishment code A
B, establishment name
So establishment code number is different.
is different, Lordship. Exactly.
Then his establishment code
Lordship,
number
that's why
is.
we doubt, Lordship, we doubt the authenticity of the of the company, Your Lordship.
Okay.
When
Okay, we'll get-
submitted their bid, Lordship. This is just for,
Okay, well,
Lord, only one clarification I can give. So far as NFPC is concerned, documents from page 406 to 411 in their rejoinder, these documents were never before the NSPC. We never looked into it.
Lordship, we found it from the website.
So they have done the research.
Yeah, we have
And
done
they
the
were subject to investigation. Now, my lord, our decision was not influenced by this. My the respondents, if lawyers are there, they may explain whatever. it is.
and
We know.
thereafter, what
But
they
in
have
KD
suggested
Sharma-
before the learned single
But
judge,
at that time, we couldn't find that anomaly, so Lordship, I accept.
learned single judge, before the learned single judge, they have produced the certificate itself.
No, no, Lordship.
It was.
Certificates were not produced.
A
Your Lordship.
certificate by not the chief justice asked for it, then initially we took a print from the portal. On portal, we checked from the portal actually.
We never got the.
My lord, there is no question of our getting a certificate physically because papers are not maintained. Everything is in the portal. So my lord, whatever was in the portal, we initially were given the printout of the portal. Then my lord, the chief justice said, I would like to see the certificate. Then my lord, respondent 6 was contacted. Then respondent number 6 brought the certificate.
Where is that?
Physically. That is, my lord, the part of the just a minute. Part of, my lord, the page 3, sorry, my lord, the affidavit page 371. Page 371 is the affidavit we filed. This certificate, my lord, will find.
371.
Yes, my lord, sorry. The page 385.
385.
385. And only the copy. Affidavit by respondent 2 to 5, filed on 25/9/23. The continuation, the page is 385.
The name is.
385.
Sorry, it's GLD. I'm sorry. I'm pointing out the wrong thing. I'm sorry, Lord. I'm sorry. Sorry. It is another. I'm sorry, Lord. I made a mistake. Affidavit bringing on, sorry. It is affidavit dated 29/9/23, page 387 to 391. Page 390 is the affidavit. Sorry, that certificate.
390.
Yes, 390. It is pre-existing. Dated 9 to 2015.
390. Yes, Provident Fund code number and intimation letter.
Yes,
Brahmaputra.
they brought it. That is the physically not this, the certificate, this side. It is dated 9 to 2015.
Why is the address changed?
In the other one also is Delhi only.
No.
The papers that were before us,
No.
the Delhi address was given.
No,
Then they may explain all this, I don't know, what is what.
address is also changed.
The earlier,
Address change also. This is from Mahipalpur. इसमें देखिए सर इसमें देखिए सर
fine.
just a minute just a minute
The earlier Talan, same address.
no the address
The certificate is matching with the Chalan, which they submitted on in our response.
so see that
That is at page
355,
407 and 407
355 of the paper forms.
407 is Brahmaputra infrastructure.
You know, the respondent, the research papers and.
एड्रेस देखिए सर नेक्स्ट पेज में 407 and
407 पे चलिए फोन नंबर
407
ये फोन नंबर है कॉम्प्लेक्स ग्लोबल इसके फोन नंबर
Page 355 and 390, address is same.
report number 3 उसका और next page में वही address है next page में Next page. Address is third floor from road and Guwahati.
ये दूसरा, ये code number is what I said. This code number is 496000. And his code number is, and the company which is in consideration, its code number is 7000.
How do you call yourself, Mr. Who appears for R6? How do you call yourself? How do you spell yourself? Should have been. What is your code number?
DL, the one beginning with D.
Hmm?
The one beginning with DL. DLCP. DLCPM
Where is your office?
in New Delhi. Hello,
What about the Guwahati office?
in fact, there were two that we've already shown. There are technical errors where instead of Brahmaputra, it is Brahmaputra. We've already filed application before the authority for correction.
What about the number?
Number, what has happened was, initially there was a requirement that for all regional units, there should be a separate code book. That requirement was done away with by the peer department. And they said establishments which have different regional units can operate with a single registration. Which is why initially we had a separate registration for Northeast, which was surrendered, and we are operating with that Delhi.
Delhi, what is the Delhi number?
DLM 035.
Where do you get?
7,000.
Where do you get?
It's page 39.
The same as that in Chala. 355, say, Rocket may match it with 355.
No.
So Das, is it your categorical case that these are two companies, different companies, or you
I
just?
have done my research, Lordship. I have found, Lordship, there is two different names, Lordship.
No, is it your case? It may be some
Lordship, without any
typographical error.
substituting documents, Lordship.
No, if you are making an allegation, this amounts to allegation of kind of a fraud. Are you making an allegation of fraud that forged papers have been used?
Lordship,
Of
that
another
I have to take
company?
instruction from my client, your Lordship.
That is not enough.
And
where is the appellate stage?
you have not raised this point before the learned single judge.
Lordship, because lately it came to the knowledge of the client, Lord.
Then it's okay, we'll consider. Arguments heard at admission with the consent of the parties. Arguments heard, arguments finally heard at admission stage. Order reserved.
Much obviously.
Yes. Item number 21.
Much obviously.
Lordship may fix any other date if that is convenient to this honorable court.
Maybe after the Bihu Lordship.
The date may be fixed, Lordship.
They were about to file an alternative Lordship, they have filed.
What's the controversy about that difference between the pension and something else?
No,
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 Lordship.
this is
So the disclosure of the
the place of.
details of the child and the parents. So it amounts to, they are alleging that it amounts to the violation of the right of privacy.
2 weeks.
No, can you fix a date?
Date you may
Lordship,
ask.
highly obliged.